the subcommittee will reconvene. The chair recognizes the fact that there might be members of the subcommittee who did not have an opportunity to ask questions of our witnesses before we recess. However, the chair is very cognizant of the witnesses' time and will take this time to go into a second round of questioning. And if there are members who come in who have not asked questions in the first round, then the chair will prolong their questioning for us to 7 minutes. So with that, the chair recognizes himself for 5 minutes for 2 minutes of additional questioning. In his white paper describing the proposed regulatory reform, the Department of Treasury stated clearly that, and I quote it, the FTC should retain authority for dealing with fraud in the financial marketplace, end of quote. Despite this assurance, the proposed language appears to weaken FTC's authority in this area. FTC would retain the authority to enforce against unfair and deceptive acts and practices using the FTC Act. However, the FTC could not add any statutory claims such as the Truth in Lending Act or the Equal Credit Opportunity Act to a complaint without first referring the case to the new agency and waiting 120 days for the agency to decide if it wants to take the case. Chairman Leibowitz, let me ask you, how will this change impact the FTC's ability to pursue financial fraud? Could the FTC pursue one part of a case while the other is under consideration at CEPA? Or would you expect that it would simply not bother with additional claims? Will FTC's cases be weakened if they only rely on FTC Act claims?
Well, I think I'll go back to this mic. I think, Mr. Chairman, that's a great question, and keeping in mind that we're at the beginning of the legislative process, not near the end of the legislative process, those are questions I think that this committee will want to think through as the legislation proceeds forward. Last week, we brought a bunch of cases which we called Operation Shortchange, and it was about scams that were hitting people in economic distress, and a lot of those were basically fraud claims under the FTC Act. But one of them involved the Electronic Funds Transfer Act under and Reg, I think it's Reg E. Now, Reg E would go to the new agency, and so this would sort of invoke two parts of your question, or two components to your question. One of which is, would we have to wait 120 days to bring this case while there's ongoing harm? And then the second issue is really, what is the nature of our backup authority? And I want to say, Mr. Barr and I have been working through this with our staffs and very, very productively. You know, I worked on the Hill for 13 years, and I never wrote a piece of legislation, or for my bosses then, that didn't change as it went forward. But I think these are precisely the questions that we worry about at the FTC. We want to make sure, and I know Mr. Barr does too, that this legislation is as effective as it can be for the consumers that all of us represent. And so I think it's important that you focus on this.
Well, it seems that the FTC, the consumers would benefit more if the FTC didn't have to solely rely on the so-called backdrop authority. Do you agree with that?
Well, again, I mean, from my perspective, and you know, I'll turn the mic over to Mr. Barr in a second, but from our perspective, if the backup authority is weak, and you know, we have backup authority involving the SEC and the CFTC, which we use very rarely, only when we need it. But here, sort of a couple of points. One is, as the transition is happening, if this legislation is created, you want, you know, and certainly even after very good lawyers are transferred and attorneys and jurisdiction, you know, it's going to take a while for this new agency, as Mr. Barr knows better than anyone, to ramp up. And I believe that they're going to want us involved using our backup authority probably more earlier than later. Now, we understand that they will be, they'll have primary jurisdiction here, but I think it's very important that the backup authority be robust so that we can sort of help out, and also so that when we have these cases that involve malefactors that don't fit into the old or new silos, that we can effectively go forward and stop ongoing harm involving consumers.
Yeah, before you, Mr. Barr, and the chair is really cognizant of the fact that his time is almost up. We'll give the ranking member whatever time he may consume. But I have just one question. Earlier you stated that you had lost some personnel. Is these the individuals that was transferred to Treasury?
We have we have
and if these are the same individuals,
we have one or two people who've gone over.
And what is the purpose of them going over to Treasury?
I'm sorry.
What is their purpose for going over to Treasury? Are they transferred? Are they on loan to Treasury, or are they reassigned to Treasury?
Oh, I think they're on detail to.
They're on detail to Treasury. What's the purpose of them being on detail to Treasury?
What does that mean?
What is the purpose of them being on detail to Treasury? What are they doing over there?
I think they're. Well, I'll turn that over to Mr. Barr. But I do know that the one person I know who is on detail to Treasury is a fabulous attorney and really cares about consumer protection and also the FTC.
All right, well, once you turn it over to Mr. Barr, now let him answer the question. Thank you. Mr. Barr, would you begin your answer with that last question, and then you can respond to the other questions?
Sure, and then I'd be happy to address the broader points. We have on our staff a terrific attorney from the FTC who's come over on detail and is going to be a permanent employee of the Treasury Department working on consumer issues. Oh, yeah. With respect to the broader sets of questions, I would just say, first and foremost, the chairman and I have been working closely together, committed to working closely together on these sets of issues. On financial fraud, it's clear from the President's proposal that it would not in any way diminish the FTC's ability to take on financial fraud cases, as is stated in the white paper and in the legislation. The FTC would retain its authority and its duty to bring financial fraud cases without delay. With respect to coordination, there are many issues that the agencies will want to coordinate on. The 120-day measure is not like the existing authorities that the FTC uses, where it's the primary entity doing enforcement. This is a proposal that kicks in if the FTC is doing its work and finds a problem. It can let the new agency know, the consumer agency, know about it. It doesn't have to wait, as the FTC does today. It doesn't wait until it's gone through its investigation, gone through the whole charging process and gotten it all ready, and then refer to the Justice Department. It's totally unlike that. This is a chance for the FTC to let the new agency know about a problem that it sees that's come to its attention. So it's just it's a fundamentally different mechanism. We're committed to being sure that that in no way delays any financial fraud cases. And with respect to the transition issues, again, the FTC and the bank agencies will have large transition issues. We're committed to working those through. And as I mentioned to Representative Schakowsky, Treasury is responsible for ensuring that transition happens smoothly, and you can hold us accountable for that.
With that, the Chairman, my time is concluded. Now, Mr. Donovan is recognized.
Thanks, Mr. Chairman, and welcome back. Mr. Lieberman, Leibowitz, excuse me. Uncertainty is one of the key factors behind the perpetuation of our current economic crisis, and granting a new and unknown regulatory agency with this broad scope of power could place a dangerous level of uncertainty into the financial markets. Do you think that it might be better to have an experienced regulator such as the FTC with a long and trusted history of working with business at the helm with these new powers?
Well, as you know, I'm very fond of the Federal Trade Commission, as you are. I would say this. You know, as you know, I testified here a few months ago that we thought we could do the consumer protection mission involving predatory financial instruments. The proposal that has been developed, though, is one that is broader than that. It has bank examiner components. It has compliance proponents. So those are not things in our core competency. You know, again, we're a creature of Congress. We're an independent agency, and so we will, you know, we will do whatever you tell us we're going to do, and then beyond that, I would say this. I just want to come back to my initial point, which is based on what we've seen in this marketplace and the restrictions that we've operated under. I do think that with these issues worked through, and I believe they will be, I do think that having this new agency and the FTC both going after unfairness, deception, fraud is considerably preferable to the status quo.
And we agree on that. I mean, I think the issue is how you go about it. I will say, though, that meeting with the bankers in my district back home, they're afraid of this, and I think that's the uncertainty question is a legitimate question. And
well,
if it does bring the specter of increased regulatory management over the industry, not that something has to be done in order to get to correct the mistakes of the last year, but you know, what's it going to do to the industry's willingness to get out there and unfreeze liquidity like we're all wanting to? I'm happy if you want to respond.
If I could just add to Chairman Leibowitz's comment on that, I think that a key new factor is this agency would have all the supervisory and examination authority it needs, not just with respect to banks, but also with respect to non-bank competitors of those banks. So I understand that many banks are worried about the scope of the new Consumer Financial Protection Agency. I appreciate those concerns. I think the additional upside for them is that their non-bank competitors will have the same high standard that they need to meet, the same level playing field, the same consistent rules. So they don't have to worry. Community bank and a credit union doesn't have to worry about
that. Kind of tells me that you're just broadening the uncertainty to include the entire financial markets. You're not.
No, I think what we're able to do, sir, with respect is to.
It seems to me the uncertainty is being broadened. That doesn't answer the question about uncertainty and that the banks are afraid of this kind of legislation.
I think what we're able to do is create a high, consistent, clear standard. We're able to reduce regulatory burden in many cases. For example, combining the TILA-NRESPA reforms that drive everybody crazy and don't help consumers. We need a single, uniform, simple standard for disclosure that applies.
I'd suggest that you need to convince the banks because they're the ones that are expressing the real concern. If I may, though, Mr. Barr, I do have a second question, and that is that President Obama has stated that a streamlined system will provide better oversight and will be less costly for regulated institutions. But the preemption statutes in the bill create a floor rather than a ceiling for state regulation. Doesn't that mean we're looking at 51 different versions of this thing by giving the preemption statutes to the state? And how does that not conflict with President Obama's statement that we're looking at a streamlined system?
Well, as you know, the states have long played an important role in consumer protection. I think one of the upsides of living in our country is that we have independent states that make independent judgments about.
They have not had preemptive status in this situation before.
They have not been able to apply state laws in some context to national banks. But they certainly have been very active in the consumer area across lots of different products and services in the past.
Do you think that could lead to 51 different versions of this throughout the state?
I think we're much more likely to see a high standard at the national level. I think it's very rare if you set a good high standard at the national level, you're going to find it very rare for states to go off in their own way. But sometimes states are right. Sometimes states protect consumers in innovative ways, and our view is we shouldn't block the state's ability to do what the states think and their judgment is right.
All right. Thank you, Mr. Chairman.
The chair thanks the witnesses, and we want to thank you for, oh boy, no, we don't. The chair recognizes Dr. Gingrey for 7 minutes for the purpose of questioning.
Well, Mr. Chairman, thank you for your generosity of time. I'm sorry I missed the first round, and I appreciate you letting me ask some questions. And I did want to ask Secretary Barr, in your testimony, you indicated that we need only one agency charged with protecting consumers for financial products and services. As one of the principal architects of the administration's plan and the proposed Consumer Financial Protection Agency, you lay out a very broad and sweeping changes that will fundamentally change a number of government entities, of course, including the FTC. However, while this is still in the early stages, there are some concerns held by members, including me, that an overly broad new regulatory agency will have the same effect of hitting a nail with a sledgehammer. In these efforts, under the guise of uniformity, I feel that there may be some different standards set for industries within this proposed agencies. For example, I've heard that some suggestion that small banks should be exempt from some or all of the rules written by the proposed agency. And the drafted legislation contains exempted authority based on asset size. Is it the administration's plan to apply different consumer protections depending on whether a customer transacts with a small or a large bank? And furthermore, if you intend to carve out smaller institutions, what are the types of rules they would be exempted from, and what is the policy reason for carving out these institutions?
Thank you very much for that set of questions. I do think that our proposal does involve sweeping change that in our judgment is essential to protect consumers. Our old system was fundamentally broken, and we do need fundamental reform. With respect to smaller institutions, we don't expect to see, would not expect that small banks and big banks would have different rules of disclosure. But you may see differences in, say, how much examination or supervision there would be. In the bigger institutions, as we do today, on site, there are examiners on site year-round. You wouldn't want that for a small bank. So you may see differences like that, but not differences in the basic standards affecting consumers. Those would be uniform across the board. So if you walk into a bank, or you walk into a credit union, you walk into a big bank, or you go to your independent mortgage broker, or you go to an independent mortgage company, you get the same simple mortgage disclosure. So consumers can understand what they're getting.
Chairman Leibowitz, as you outlined in your testimony, there will be a number of changes to the FTC as a result of the Consumer Financial Protection Agency, if that becomes law. Many responsibilities will be pulled from the current jurisdiction of the FTC and be given to this new agency. With all of these proposed changes, what then will be the role of the FTC in this new landscape, and how much of that new role will be duplicative of this proposed agency? You guys have been doing a good job. You know, we are appreciative of that.
And we appreciate, you know, and are heartened by what you said about our agency. I do think we do a good job, and we have terrific attorneys who really care about enforcing the mission of the agency, and good commissioners who are also committed. You know, we'll still have, let me just say, we'll still have all of our competition authority, right, our antitrust authority. we will continue to do all the other things we do, whether it's fraud or privacy outside of the financial context, or, you know, advertising and marketing practices. And then we'll continue to stay involved here, I think, especially during the transition period and hopefully beyond with concurrent jurisdiction. You know, look, there are, as we know in this room, and as you guys know better than anybody else, there are a lot of bad actors out there who are, you know, trying to rip off American consumers. And so, you know, by growing the federal ability to go after these malefactors, that can only help even the playing field, right? I mean, what we do at the FTC, and I think we do it really well, but it's a sort of triage, right? You know, we look at different cases, potential cases, and whereas we're going through an investigation, and we say, which one can we best leverage? Which are the ones that, you know, are the greatest harm to the greatest number of people? Which are the ones that might make better, change bad case law, for example? And we're always making decisions based on sort of the lack of resources that we have. We just try to do the best job.
Well, let me reclaim my time just for a second. I did want to ask you one other question. Look, we don't disagree with the need for oversight, but it seems to me that in this current financial crisis that we're in and all of these bad loans and toxic assets and all of that, that the oversight got really heavy after the horse had already left the barn. Right. And so that's kind of a concern, and there's always the concern that the oversight it becomes too much, so restrictive after the fact that these institutions, particularly your small banks and lending institutions, can't function. And I certainly see this across my district in privately held banks, smaller banks, that the oversight should have been steady and consistent, and it always should be, but yet, you know, when some catastrophe occurs because somebody was not minding the store, then all of a sudden the oversight comes down on these institutions to the point that all of a sudden they go out of business. It hurts the local community. And but let me just ask you, in the little bit of time I've got left, you mentioned to us what the FTC would be able to continue to do. Mm-hmm. What percentage of what you currently do is that? Does that represent 50% of your current responsibilities, 25%? Are you losing more than 50% of what you currently are charged to do?
No. You know, I think it would be more like in terms of, if I think it through in terms of resources, I'll get back to you with a response, but I would say it is more like 5 to 10% of what we do, and of course it's been an area, as you know, that we've been concentrating on more and more because it's very important to American consumers. Many of whom are suffering from, many of whom, almost all of whom, are suffering from some.
Well, I would appreciate it if you would specifically get back to. I think it's important that we know that.
It is.
Mr. Chairman, thank you for your patience and generosity, and thank the witnesses.
The chair, again, the chair thanks the witnesses for the use of their time. You were very generous to us in terms of using your time, and we want to know that you have really contributed significantly to this process, and we are better off because you testified today and to help us move along on this new proposal. And so we will be in touch with you in the future, and the chair wants you to know that we will, there'll be, we will give members 72 hours to ask questions in writing, and if you will respond to them within a reasonable amount of time, the chair really will appreciate it. So thank you so very much.
Thank you. Thank you, Mr. Chairman.
Thank you.